Today, we will delve into an important area that often receives insufficient attention in healthcare education: the court systems and their impact on chiropractic practice. Specifically, we'll be comparing the California state court system and the federal court system. Understanding these two systems is essential, not just for chiropractors but for all healthcare professionals. When most people think about court cases, they tend to picture dramatic trials they see on television: lawyers cross-examining witnesses, the judge delivering a powerful verdict. However, in real life, especially in healthcare, legal proceedings are much more complex and procedural. For chiropractors, understanding the basics of the court systems is particularly important because you may find yourself interacting with the legal system in several ways. Whether it's a patient claiming injury after treatment or a licensing board reviewing a complaint against you, having a strong grasp of which court system has jurisdiction over your case can make a big difference in how you approach it. One example to consider is a malpractice case. Let's say a patient sues you for negligence after a treatment they believe led to injury. In most instances, this will be handled within the state court system, as malpractice laws are state-regulated. However, if the patient is a Medicare beneficiary and the issue also involves billing fraud, the case could escalate to the federal level. The court system you deal with has implications for your legal strategy, the applicable laws, and the potential outcomes. So today, we're going to break down how the state and federal court systems operate, with a focus on the California courts. Let's start by looking at the California state court system. Like all state court systems, it has its own structure and hierarchy, which can be broken down into three main levels: the superior courts, the courts of appeal, and the California Supreme Court. Most of the legal issues chiropractors encounter, such as malpractice claims, professional disputes, or complaints related to the scope of practice, will be handled within this system. California's state courts are designed to handle cases arising under state laws, which are particularly important for healthcare professionals because many regulations governing professional behavior, patient care, and malpractice are state-based. For example, California has its own set of laws outlining the acceptable scope of practice for chiropractors, which we've been learning. A chiropractor who performs a treatment outside of that scope could face a licensing board investigation or even a civil lawsuit for professional misconduct, which would likely begin in the California state court system. At the base of the California state court system are the superior courts. These are the trial courts where most legal cases begin, and every county in California has its own superior court. These courts handle a broad range of cases, including civil disputes, criminal cases, family law matters, and probate cases. For chiropractors, this is where most of your legal interactions would take place if you were involved in a civil lawsuit, like a malpractice claim. Let's consider an example. Imagine you are sued by a patient who claims that an adjustment you performed caused them injury. This case would most likely be filed in the superior court of the county where your practice is located. The court would assess the facts, hear from both parties, and issue a verdict. The decision made here can be appealed, but this marks the beginning of the process. The superior courts are really the workhorses of the California judicial system, handling thousands of cases a year. The next level up in the state system is the California Courts of Appeal. These courts review decisions made by the superior courts. In legal terms, they don't conduct a new trial but rather assess whether the law was applied correctly in the trial court. They focus on legal errors, not factual disputes. For chiropractors, this means that if you lose a malpractice case in the superior court and believe the judge made an error in interpreting the law, you can appeal the decision to the Court of Appeal. Let's expand on our previous example. Suppose you lose your malpractice case, and the superior court orders you to pay damages to the patient. However, you believe that the judge didn't properly consider evidence about the standard of care for chiropractors in California, and you felt that your treatment was reasonable, and perhaps there was information not included in the decision. You might choose to then file an appeal, arguing that the court misapplied the law or procedural rules. The Court of Appeal would then review the legal aspects of the case to determine if the superior court's decision should be upheld or reversed. At the top of the California state court hierarchy is the California Supreme Court. This is the highest court in the state, and it has the authority to review decisions from the courts of appeal. However, the California Supreme Court is selective in the cases it takes on. It generally only hears cases that involve important questions of law, significant public interest, substantial media coverage, or conflicting decisions from lower courts, and it requires another party to step in. So, it's quite rare for cases to reach this level, especially for routine legal matters like individual malpractice claims. One of the more relevant scenarios in which a chiropractic-related case might reach the California Supreme Court is when a groundbreaking legal issue arises. A notable example would be a dispute over the legality of a new chiropractic technique that hasn't been addressed in California law before. For instance, if the lower courts are divided on whether a particular practice is within the chiropractor's scope of practice, the California Supreme Court might decide to take up the case to resolve the issue once and for all. Decisions made by this court are final and binding on all lower state courts in California. Now let's switch gears and talk about the federal court system. Like the state system, the federal system also has three main levels: U.S. District Courts, U.S. Courts of Appeals, and the U.S. Supreme Court. The primary difference is that federal courts hear cases involving federal law, which includes the U.S. Constitution, federal statutes, and cases between parties from different states. For chiropractors, federal court involvement is less common but could arise in specific situations. For example, if your practice is involved in a Medicare billing dispute or if you're accused of violating a federal healthcare law, your case would likely be heard in a federal court. Additionally, if you are practicing in multiple states and a dispute crosses state lines, the federal court system may become involved. While most chiropractors deal with state laws, federal regulations also play a significant role, particularly in areas such as Medicare or Medicaid billing and fraud. The U.S. District Courts are the trial courts in the federal system, just like the superior courts in the state system. These courts handle the initial hearings for cases involving federal law, with 94 district courts spread across the United States. In California, we have 4 U.S. district courts, located in the northern, central, southern, and eastern districts. For chiropractors, federal cases in these courts could involve issues such as Medicare fraud. For instance, let's say a chiropractor is accused of improperly billing Medicare for treatments that were not covered. This type of case would be heard in the U.S. District Court because it involves a federal program. Because the federal government covers Medicare and Medicaid, federal fraud and abuse laws apply. Another example could be a chiropractor practicing near state lines, such as in California and Nevada, and a patient from one state sues for malpractice. This could also potentially move into federal court due to jurisdictional reasons. The U.S. Courts of Appeals, also known as circuit courts, are the next step in the federal system, similar to the California Courts of Appeal. These courts review the decisions of the U.S. District Courts, focusing on whether legal errors occurred during the trial. There are 13 circuit courts in the United States, each covering different geographic regions. California falls under the Ninth Circuit, which covers a broad range of western states. Suppose a chiropractor loses a Medicare fraud case in a U.S. district court and believes the court misinterpreted a federal regulation. In that case, they can appeal to the U.S. Court of Appeals for the Ninth Circuit. The circuit court would then review the legal aspects of the case, similar to the appellate process in the California court system. At the top of the federal system is the U.S. Supreme Court, the nation's highest court. Like the California Supreme Court, the U.S. Supreme Court selects only a small number of cases to review each year, typically those involving significant constitutional questions or legal conflicts between federal appellate courts. It's unlikely that most chiropractors will ever have a case that reaches the U.S. Supreme Court. However, landmark cases that significantly impact healthcare policy, patient rights, or the interpretation of federal healthcare laws often reach this court. For instance, the U.S. Supreme Court has been involved in major healthcare cases, such as the Affordable Care Act, which have wide-reaching implications for all healthcare providers, including chiropractors. To wrap things up, let's talk about the key differences between the California state court system and the federal court system. The biggest difference lies in the types of cases they handle. State courts are responsible for cases involving state laws, which for chiropractors include malpractice, licensing disputes, and scope of practice issues. Federal courts, on the other hand, handle cases involving federal laws, such as Medicare and Medicaid regulations, healthcare fraud, and constitutional issues. Jurisdiction is another important distinction. A malpractice claim will almost always be handled in state court. However, if it involves a federal law, such as the Americans with Disabilities Act, it may be transferred to federal court for consideration. Knowing which court system you're dealing with is crucial because it impacts the legal rules and procedures you'll face, as well as the potential outcomes. Now, let's discuss the appeals process, which is crucial for chiropractors to understand if they become involved in litigation. Whether in state or federal court, losing a case at the trial level doesn't always mean it's the end of the road. Both systems have an appeals process, but the structure and rules differ. In California, cases can be appealed from the trial courts to the California Court of Appeal. If the Court of Appeal decision is contested, the California Supreme Court may choose to review it, although it only selects cases with broader legal significance. In the federal system, after a district court ruling, the case can be appealed to the U.S. Court of Appeals. From there, the U.S. Supreme Court can choose to review the case, but again, only in rare instances. It's important to note that not every case is eligible for appeal. The appeal must be based on a legal error made during the trial, not just dissatisfaction with the outcome. Additionally, the appeals process can be lengthy and costly, making it necessary to carefully consider the consequences before proceeding. Understanding the appeals process is crucial because it offers a mechanism for correcting errors and seeking justice in cases where you feel the law wasn't properly applied. Chiropractors often interact with the state court system, especially in matters such as licensing disputes or allegations of malpractice, which are typically handled at the state level. However, it's crucial also to understand when federal law may come into play. For example, cases involving Medicare fraud or violations of federal healthcare regulations fall under the jurisdiction of the federal government. While most legal encounters occur in state courts, being aware of federal law and its potential impact on practice is essential. Understanding both court systems empowers chiropractors to navigate legal issues more effectively and avoid costly mistakes. When exploring the legal landscape, chiropractors should rely on official sources to understand court structures and legal processes. For California-specific matters, visit the California Court's official website at www.courts.ca.gov. This site outlines the state court system, from trial courts to appellate courts and the California Supreme Court. For issues involving federal jurisdiction, such as Medicare fraud or constitutional questions, consult the U.S. Court's official website at www.uscourts.gov. It provides detailed information on district courts, courts of appeals, and the U.S. Supreme Court. These resources are essential for staying informed and navigating legal responsibilities with confidence. The study referenced here is by Stander et al., published in 2021 in the Journal of the International Society of Sports Nutrition.